Welcome to Patent Podcast with noted inventor and patent attorney Chris Maiorana. Each week, Chris answers your questions on patents, trademarks, and inventions. Now, here's Chris Maiorana.
Chris, what is a patent appeal?
So when the Patent Office first examines a patent application, they issue an office action that typically has at least some sort of rejection to the claims, although it could be just an allowance of all the claims. The prosecution process in modern times, they call it streamlined prosecution, which means you get one chance to amend your claims. After you amend the claims, the Patent Office is either going to allow them or continue to reject. If they send a rejection, then that's typically marked final, and then you have the chance to appeal at that point. So you don't have to appeal, but you have a chance to appeal.
So what is a brief?
So a brief is typically an appeal brief that's filed as part of your appeal process. So it's a long document that itemizes all of what the applicant believes are the flaws in the patent examiner's positions.
Okay, content, what's that?
Yeah, so the content of the brief, it's divided into multiple sections. You have to talk about what your pending claims are. You have to note what the rejections outstanding on the record are, and then you make your arguments of why you think your claims are patentable. Ultimately, most of what we do as a patent attorney gets back to trying to make arguments why your claims are patentable over the art. So when you go to an appeal, you're basically stepping it up to the next level. So you made arguments with the examiner, he didn't agree with them for one reason or another, and you're taking it up to the next level. So that's going to go to the patent board.
Any other options?
You don't have to appeal. You could amend your claims again, or you could, you can always abandon your claims as well. But the question is, you either amend again or you appeal. So if you think you already amended your claims enough, or you just don't want to amend your claims because you think they're already patentable over the art of record, then and the patent examiner doesn't agree, then you can go on to an appeal.
Okay, so when do you decide whether to appeal?
Yeah, that's an interesting question because you really have to take one step back on when you're going to decide that. So we look at an after final rejection from the Patent Office and decide at that point pretty much whether we're going to appeal. The first step is, do we need to amend the claims to get past this rejection for the art that's outstanding? If you don't need to amend the claims, then you're going to argue only in that after final rejection, but that is making a commitment to go to an appeal. So if the patent examiner doesn't agree with you, you don't really have the choice to go back to an RCE at that point because you haven't made a claim change. So the Patent Office changed the system that the examiners use. They get these, they call them a count. So the patent examiner gets a count for sending out the initial search and another count for finalizing the case. So in the old days, the examiner didn't get his final count until after the appeal was over. So he had a little bit more leverage. So now they get a count for filing their examiner's answer. So it makes it easier for them to basically make their quota. When I say count, that's not the same thing as a count in a patent interference. A count in this sense is the examiner's internal quota system. He has to get so many counts per pay period and per quarter and per year.
Okay.
In an interference, the count is the conflicting subject matter between the two, either the issued patent and the competing application.
Okay, and I've heard that appeals are difficult to win, but you win most of them. So why is that?
I think it's because we select which cases carefully that we're going to appeal. So we're looking for a case that the examiner made somewhat of an unreasonable argument or didn't adapt his argument to the new facts in the case. And it just seems like the examiner's being unreasonable. So some cases will do a second round of amending or maybe even a third round of amending, especially if there's new art that's come up. But if the examiner really hasn't brought up anything new and we think we have a strong case for an appeal, then we'll appeal it. So we don't appeal that many. I think we do maybe 1 or 2 per quarter, so that we're not just giving up to the examiner's arguments on all the cases, but we appeal enough that we have that as a backup position. It's a little bit like a bluff in poker. So you don't appeal every time, but you appeal enough so that they know that's a possibility. And in general, the examiners don't like appeals because that's someone else looking over their shoulder, and if they lose, it's potentially a mark on their credibility. It doesn't hurt them on their overall ranking at the patent office, but it's a negative for them because someone else is saying, "Hey, you were wrong on this, and the attorneys were right."
Yeah. Okay. Yeah, that makes sense. So how long does it take to get a decision?
Yeah. What's interesting is the board now is claiming to be fairly backlogged with these things. So a few years ago, they hired a bunch of new attorneys at the board level, and then the examining attorneys tend to, patent examiners and the attorneys working with them tended to push more cases to the board, and the pendulum has kind of shifted, and this happens a lot. The pendulum shifts back and forth. So in this case now, the board is busy, so they've turned around and raised the maintenance fees so that they can hire more people at the board to cut down on this perceived backlog. So I think we have the oldest one is like 3 years out, but most of them come back in about 2 years, which does seem like a long time. But the good part of it is you do get a patent term adjustment if you win a successful appeal. If it's an important patent, those extra years in the PTA get added to the end of the patent, so it potentially could be even more valuable.
Thank you for listening to Patent Podcast with noted inventor and patent attorney Chris Maiorana. Join us next time as Chris answers your questions on patents, trademarks, and inventions.